Welcome to the Law Report. This is episode 90. A question was posed to me recently. If the police in general or police officer have the authority to tow away a person's motor vehicle, in short, the answer is yes. And I'm going to examine section 44 of the Road Traffic Ordinance to solidify my answer. So I will be back shortly to discuss section 44 of the Road Traffic Ordinance. But before I do, let me say this is not legal advice, should not be construed as such. And for legal advice, please contact an attorney of your choice. Welcome back. A police officer under section 44 of the Road Traffic Ordinance has the authority to tow a person's motor vehicle under the following circumstances. Where A, that the vehicle has been abandoned. B, where it is parked in an unlawful and unsafe manner. C, where it is left in such a condition as to constitute a danger. And it could be a danger to the public, a danger to the environment, etc. Where it was involved in an accident. Where it was used for public service without appropriate license. So those illegal jitneys up and down on Leeward Highway would fall into this category. Where the vehicle was driven without the appropriate certificate of insurance. So a vehicle to which there is no certificate of insurance can be towed by the police. Now, according to section 44, continue on with section 1, the police officer may take charge of a vehicle and drive or tow it or cause it to be driven or towed to a place authorized by the Commissioner of Police to be used as a vehicle pound or to any other place considered by the Commissioner of Police to be appropriate. So the place must be authorized by the Commissioner of Police to be a vehicle pound, or two, the place must be considered appropriate by the Commissioner of Police. Now, section 44, subsection 2, the Commissioner shall, as soon as practicable, give notice to the owner or person that last had control of the vehicle driven or towed away under subsection 1 that it has been driven or towed away and requiring him to remove the vehicle. So when a vehicle is being towed for any of the reasons previously mentioned, the Commissioner of Police, as soon as practicable, is required to give notice to the person who has control of the vehicle. That is the person who last had control of the vehicle, or the owner of the vehicle, that the vehicle had been towed or driven away by the police, and required that person to remove his or her vehicle. In other words, come and get it. Subsection 3, the owner, a person last having control of that vehicle, or the vehicle which was driven away or towed away, under subsection 1, shall pay the Commissioner of Police such fees as may be prescribed in respect of the driving or towing away of the vehicle under subsection 1. So in other words, the person whose vehicle was towed away, whether the owner, the person who last had control, will be required to pay the expenses associated with the towing of the vehicle. Subsection 4 of section 44 states that the owner or persons referred to in subsection 2 shall, in respect of the vehicle detained in a vehicle pound, pay to the commissioner such fee as may be prescribed in respect of every day or part of a day for which the vehicle remains in the pound. So the longer the vehicle stays in the pound, the person will have to pay what amount to storage fees. So the quicker the person could remove the vehicle after being given notice to come and remove it, the less expensive it would be for that person. Subsection 5 states that the Commissioner of Police may retain a vehicle at the pound which has been involved in an accident, but without charge to the owner in respect of the retention until the conclusion of the police investigation as to the cause of the accident or until the vehicle is ordered to be released by the court. So if the vehicle is towed away where there is an investigation as to the cause of the accident, or where the person has been charged in relation to the accident, the police shall retain this vehicle at the vehicle pound without any charge or any fees to the owner or the person last in charge of the vehicle until the conclusion of the investigation, or until the vehicle is so ordered to be released by the court. But there's a very interesting subsection to section 44, and that is subsection 6. It says, no action shall lie against the government or a police officer for damages in respect of or in respect to a vehicle or loss or damage to property in the vehicle caused as a result of any action taken under this section. So, if the police under this section were to tow away a vehicle and impound it, and the vehicle were to be damaged or any property in the vehicle became lost, the police has no liability under this section. However, in my respectful view, police officer throwing away a vehicle, if he doesn't take it to a police pound or a place authorized as appropriate by the Commissioner of Police, and the vehicle is damaged or property is lost that were in the vehicle, I believe that the police could be held liable, because the police would then not be acting or would not have acted in good faith. Secondly, I am also of the view that if the police were grossly negligent in the way how they dealt with the vehicle, in cases that we have heard very often, allegations of police seizing vehicles and individual police officers selling them without authorization If true and if proven, then I believe that a police officer and the government could attract liability for such negligent or fraudulent actions. But in short, the police is authorized to tow a vehicle in the circumstances outlined in section 44 subsection 1A to F of the Road Traffic Ordinance. I hope that this has been helpful. If it was, please like, share and comment on this video. Most of all, I thank you for taking the time out to look at this video. Cheers, and I will see you very shortly in my next episode.